And without further ado, I will hand it over to Professor Michael Hadskis. So Professor Hadskis is a faculty member with the Schulich School of Law, the School of Health Administration, and the Health Justice Institute. Professor Hadskis teaches courses in the area of health law and tort law. His research is both interdisciplinary and collaborative and deals with contemporary health law and policy issues. So please, Professor Hadskis, take it away.
All right. Well, thanks, Matt. Greetings, everybody. Thanks for attending my online lecture on tort law liability of health professionals, the case of Millett versus Schulman. As Matt said, I teach tort law and health law. I've been teaching at the law school for 23 years. Tort law is what I'll address today. And just so that you know, tort law is one of your mandatory first year, full year courses. I guarantee it you will love tort law, or Matt will return your tuition. Am I right, Matt? Do I have that right?
Straight out of my bank account. I've got the checks ready.
Excellent. Excellent. I consider that a contract. All right, so let's move on to presentation here. So let me give you some basics on tort law in under a minute. Here you have a definition here at the top of the slide. A tort is a civil rather than criminal wrong done by one person to another person's body, property, or reputation. Basically, what we're talking here is when a person suffers some sort of harm, they can usually seek compensation under tort law for the harm that's been caused to them. The primary goal of tort law is to compensate victims for wrongful infliction of injury by giving them money. There are other remedies that are possible, but that's the primary remedy available, is to give the victim some money. Terminology. All right. So the wrongdoer is known as the defendant or tortfeasor. They're the ones to have alleged to have committed the tort. The victim is the plaintiff, and there are many kinds of torts, some of which are explored in your first year of tort law. One of those is negligence, which you have a basic sense of already, which is carelessness that causes an injury. And that can come through, operating your motor vehicle in a careless manner, professional negligence. So lawyers, doctors, other professionals can be negligent in dispensing their professional services. Manufacturers of products can be negligent and do harm to the consumers. So negligence law, and you will spend about 3 months in your tort law class on negligence, since it is the queen or king of all torts. It's the most popular or frequently encountered tort. Defamation is just another example here of a tort. You'll be generally familiar with that as well. Libel and slander law. Basically, when someone does harm to your reputation, there's a falsehood about you, that may be actionable in the tort of defamation. Then the last tort mentioned here is battery, and it's in red because that's the one we're going to be concentrating on today. The last bullet just is noting that health law is one of my areas, as was stated before, and tort law plays a key role in that context. So healthcare professionals of all stripes can be liable for a number of different torts, not just battery. Negligence, as you no doubt can appreciate. Other torts as well. Healthcare institutions like nursing homes and hospitals can be liable in tort. So it's not just people, but it can be institutions or corporations that can be held liable. Okay, so I hope you had a chance to read the Millett and Schulman document, the page-and-a-half document I think Matt distributed. This case, by the way, is covered in your first year tort law course, so take plenty of notes. And to help us with this case, we have esteemed counsel for Millett and for Schulman. And so what I'm going to do is get those folks to deliver their summary of the facts on behalf of their respective clients. And the rest of you are going to be sitting on the jury. So listen closely to those submissions made by counsel. And we'll start with counsel for Ms. Millette. So is counsel ready?
Yes.
Okay. So it's Ripsima and is going to give us the facts from their client's position.
Okay, sure. I'll just begin. So on June 30th, 1979, my client, Georgette Millette, got into a tragic car accident, which was fatal for her husband and left her seriously injured. She was taken to the hospital where she was examined by the emergency physician, Dr. David Schulman, who was the defendant, who concluded that she was suffering from incipient shock by reason of blood loss. The defendant then ordered that she be given intravenous glucose followed by Ringer's lactate, a volume expander. Nurse then discovered and informed the defendant of a card written in French on Miss Millette's persons, which was signed by Miss Millette, and stated the following: no blood transfusion. As one of Jehovah's Witnesses with firm religious convictions, I request that no blood products be administered to me under any circumstances. I fully realize the implications of this position, but I resolutely decided to obey the Bible command to keep abstaining from blood. And however, I have no religious objection to use the non-blood alternatives such as dextrin, Hamisol, PVP, Ringer's lactate, or saline solution. Miss Mallet was then examined by another surgeon, who then had her sent for x-rays, during which her blood pressure dropped and her condition worsened. At this point, the defendant, Dr. Schulman, made the decision to personally administer blood transfusions to Miss Millette while she was in the x-ray department and after she was transferred to the intensive care unit, disregarding the explicit written objections to blood transfusions and Miss Millette's Jehovah's Witness medical intervention card. Shortly after, Miss Millette's daughter arrived, learned of the transfusions, and also stated the objection that her mother would have had to the transfusion due to her religious beliefs as a Jehovah's Witness. Miss Mallet's condition eventually stabilized. She was transferred to Toronto General Hospital, where she continued to recover and was released on August 11th and is now suing Dr. David Schulman for battery.
Okay, thank you, counsel. Great job. Okay, so the jury will now hear from defense counsel. Is defense counsel ready? Anthony?
Yes. On June 30th, 1979, Mrs. Millette was rushed to the Kirkland and District Hospital after a tragic car accident that had killed her husband. My client, Dr. David Schulman, was the on-duty ER doctor and attended to Mrs. Millette, who had severe head and face injuries and was bleeding profusely. Based on his professional judgment as a physician, he concluded that Mrs. Millette was suffering from incipient shock by reason of blood loss. Dr. Schulman then ordered that intravenous glucose be given immediately followed by Ringer's lactate, which is a substitute for blood transfusion. This was standard medical practice given Mrs. Millette's circumstances. However, Mrs. Millette did not respond well to the treatment. Dr. Schulman decided, based on the lack of increase in blood pressure, that blood transfusion should be given to Mrs. Millette. This is another standard medical practice in the situation. In the process, a nurse discovered a card held by Mrs. Millette, which was read to you earlier by plaintiff's counsel, indicating Mrs. Millette's reluctance to be subjected to blood transfusion, and this card was indeed brought to Dr. Schulman's attention. Dr. Schulman transferred Mrs. Millette to a separate independent surgeon practicing at the hospital. That surgeon also confirmed that Mrs. Millette had really low blood volume that had to be maintained in order to prevent irreversible shock. The surgeon ordered x-ray for Mrs. Millette, but however, Mrs. Millette's conditions worsened significantly before the x-ray could be administered, and she was critically ill at that point. Dr. Schulman then personally administered blood transfusion as it was deemed medically necessary to prevent the almost certain death of Mrs. Millette. During the transfusion, Mrs. Millett's daughter arrived at the hospital and asked Dr. Schulman to stop the transfusion. She also signed a waiver of liability. However, Dr. Schulman decided not to comply with the request from the daughter because he believed that doing so would contravene his professional responsibility towards Mrs. Millett. Dr. Schulman's decision to not obey the card, as well as the request from the daughter of Mrs. Millett, was based on the fact that Dr. Schulman was not satisfied, was not convinced that the current instruction from the patient was to not be given blood transfusion based on his expertise as a medical professional. Some of the main reasons were that Mrs. Millett's daughter did not present any documentation stating that she had any sort of capacity to represent Mrs. Millett to give current instructions. Mrs. Millett might have changed her religious beliefs between the time that she signed the card and the time she arrived at the hospital. Mrs. Millett may have signed the card because of family or peer pressure from her community. Mrs. Millett may have not been informed of the risks of refusing blood transfusions at the time she signed the card. And finally, if she had been conscious, Mrs. Millett might have changed her mind in the face of imminent but avoidable death at that moment, and may have decided to accept blood transfusion in that instant. Eventually, Mrs. Millett's conditions gotten better, and it is safe to say that her life was saved by Dr. Schulman, who administered the blood transfusion. Thank you.
Thank you, counsel. Another fine job. Both counsel have earned their pastry and coffee. So I look forward to seeing you in September to pay up. Okay, so those are a slide. You did a nice job with the facts. I can therefore skip over those two slides which set out the facts. Okay, now jury, you've heard from counsel. I now need for you to weigh in, okay? Based on the submissions and the facts as laid out by counsel, I want you to either indicate that Schulman should be liable and should have to pay a damage award to Ms. Millett, or you're going to indicate whether or not, or indicate that you think Dr. Schulman should not be held liable. So we'll start with all those folks that Schulman should be held liable. What I need you to do is just put your hand up. So put your hand up now if you think Schulman should be held liable. Okay, we're up to 11 on my count. 12, 13. Now, wait, hold on a second. Did counsel just vote? Did counsel just join the jury?
Oh, sorry. Well, am I not supposed to vote?
That's okay. That's okay. I will have to report you to the Law Society, however. Okay, so we're up to 14. Okay, so put your hand down, all you folks. And now, all the hands down, I'm going to ask those folks that believe that Schulman should not be held liable to put your hand up. We're up to 9. Okay, there's no abstaining on the jury. You have to come down on one side or the other. I have 9 for Schulman being held not liable. Okay, looks like a 14-9 split. 14 liable and 9 not liable. All right, put your hands down. Okay, and we're going to return to the case in a minute. But first, a little bit on the law of battery. So, at the top of your slide here, you're going to see a definition of battery given by Millett and Schulman. And this is from the Ontario Court of Appeal. By the way, this is still good law. As I said, you will study Millett and Schulman, and this definition will be a definition you want to pay attention to. So, a battery is any intentional touching which is harmful or offensive to a person's reasonable sense of dignity. The other thing to note is that the plaintiff who brings the action against a defendant in battery or any other tort has the burden of proof on a balance of probabilities of establishing that the defendant has committed that tort. So here, Millett will have the burden of showing that Schulman committed the tort of battery. As I say, it's on a balance of probabilities. What does that mean? It means Millett has to adduce enough evidence at trial to show it's more likely than not. Think of it as 51%, on the basis of 51% probability that Schulman is liable for the tort of battery. Okay, which means essentially that this definition of battery has been made out by Ms. Millett. Okay, if she's able to show in a balance of probabilities that the evidence supports that. Contrast that with the criminal law burden. So tort law is known as civil law. That's contrasted with criminal law, where you'll be familiar with the burden of proof in criminal law being beyond a reasonable doubt. So the prosecutor, the state, has to show that the accused committed the crime in question beyond a reasonable doubt. That's much higher than a balance of probabilities for civil law, like battery. It is nearing, but not quite, certainty, but it's getting close. So think of a very, very high probability, substantially more than 51%. Okay, so in tort law, plaintiffs have a much lesser burden than criminal law. Okay, so the policy rationale then for the tort of battery, why is it included in the justice system? What purpose does it serve? And I've listed 4 on this slide. One is to protect bodily security from unwanted physical interference, which is basically to encourage people to keep their hands to themselves, if you will. The second, to reduce physical violence by deterring potential tortfeasors. So knowing that if you engage in an act of physical violence toward another, that you may be held liable in tort law, be brought to court, be forced to pay a damage award to your victim, that might serve as a deterrent. So those that might be inclined to engage in that kind of conduct will not. Thirdly, compensate victims who have been harmed or injured. As I said to you a minute ago, that is the primary goal of tort law, is to compensate individuals. It's not to punish. That's the domain of criminal law. That's what you'll learn in your mandatory first year criminal law course, is about punishment. Tort law, on the other hand, is about compensation. Let's make the harmed individual whole again by giving them money. In the medical context, and that's what we're dealing with here in the Millett and Schulman case, battery law is to protect a person's personal autonomy, their right of medical self-determination. Basically, people have the right to control what happens to them, like what they will submit to in the medical context and what they will not submit to in the medical context. It's your body, it's your choice. It's not the physician's view of what's in your best interest. It's your view of what's in your best interest that counts, right? So it's about respecting patients' medical self-determination. Okay, let's test your understanding of battery so far. So here's a brief hypo. We're all about hypos in law school. We're constantly throwing hypos at you. Your exams are largely hypo-based, not entirely, but you will be confronted with a lot of hypos. So here's a short one. You're in a heated argument with a classmate, Marlene Marlborough, about whether Schulman should be held liable in battery when, out of disgust for your opinion, Marlene blows cigarette smoke in your face. Could Marlene be held liable in battery? What do you say? Feel free to chime in verbally if you want right now. Does someone
think
want to
yes.
express an opinion?
I think yes, she could be held liable.
Okay, why?
Secondhand smoke, and we know that secondhand smoke has side effects. And since it's illegal to have secondhand smoke in a vehicle with a child, I feel like she could probably be held liable for battery in this case.
Okay, great. Matthew, you have an opinion.
Yeah, I would agree with that. I think she's impacting the bodily autonomy ability and the ability to like preserve your bodily autonomy.
Okay, nice. So you're on side.
I think there's another very important thing in the hypo. It says out of disgust. I think that goes to prove intent. So it is intentional. It is an intentional touch. I guess the problem would be touching, but it is an intentional, like they're intentionally putting this on me. Marlene is intentionally doing it. So I think that also helps show that it is battery.
Okay, nice. Anyone else want to weigh in? Does anyone think it would not be a battery? Jennifer.
I'm not sure I exactly like what really constitutes battery and physical harm if like you walk down like the sidewalk and you can get secondhand smoke in your face. So like I don't know, maybe that doesn't have anything to do with it, but like I don't know.
Okay,
Sorry.
no, you're asking a great question. Okay, Emma.
No, I agree with you, Jennifer. I think that because it falls on the plaintiff to show like that they were harmed or injured, I think that it's going to be very difficult to prove that that blow of secondhand smoke harmed and injured you in that way.
Okay, very nice. These are all great opinions. Okay, I'll take one more. Does anyone else have a view of the matter? Either that this would result in liability or not result in liability.
Yeah, I kind of agree with Emma and Jennifer, just because how harmful could one blow of smoke be in the face in terms of like the secondhand smoke effects? 'Cause I feel like secondhand is very long term. Secondhand smoke could be really harmful. So I think it would be about like what is the definition of like harm in that context.
Yeah, okay. Seriously, all fantastic comments. One thing I liked is that everybody was turning their mind back to the definition that I gave you, okay? And what we do in tort law is all the torts can be broken down into elements. So you can take these definitions and break it down into pieces. And so from this definition, we can break it down into physical contact. That comes from the definition. So if there's no physical contact or touching, there cannot be a battery. It can result in another tort, the tort of assault, believe it or not, which has nothing to do with assault as you know it in criminal law. Assault actually does not require touching in tort law. And we'll cover assault in tort law, but that's beyond the scope right now. So we're looking for physical touching. That physical touching has to be intentional because the word intentional appears in the definition. So it can't be accidental. It has to be desired by the individual or be substantially certain to result from the actions of the defendant. And then lastly, the contact, this intentional physical contact, has to be either harmful or, now the word or appears in the definition. I take you back to the definition. You see the word underlined, or. That's a very important word in law. It's giving a choice, two options. As long as the touching is physical and intentional, then the plaintiff succeeds by either showing that it was harmful or offensive to a reasonable sense of dignity. So that would be the third element. So here it is, the three elements. Now, applying that to the hypo, is there physical contact? I know one or more of you were wondering whether or not that would constitute physical contact. Does someone want to precisely, someone who believes that there is physical contact, do you want to tell us what that consists of? No? Jessica.
Okay, so I think blowing the smoke would constitute physical contact, because if you throw something at somebody, for example, you didn't touch them with your own hand, but it still made contact. So I would see it as the smoke is making contact with the person through you.
Very nice. Oh, Matthew.
Yeah, I was gonna say something similar. I would still say like the smoke is like a tangible thing that you can like touch someone with or like push onto somebody. Like in an element of like a smoke machine or something, even like you wouldn't want to be standing in like the center of a smoke machine if someone's blowing that on you. Like I would still argue it's a tangible thing that you can like be pushing on someone or touching someone with.
Very nice. You're both right. So the law of battery indicates that it doesn't have to be body-to-body contact. You would completely appreciate that if I pulled out a gun and aimed it at someone for the purposes of delivering a bullet to their body, that tort law and the law of battery would have something to say about it, even though I did not physically touch them with my body. So that's not a requirement. So you're absolutely right. So that is not a bar here to the plaintiff succeeding. In terms of then, what did the physical contact consist of? Well, smoke consists of particles. It consists of over 7,000 chemicals, many of which are carcinogens, known carcinogens. So yes, something has struck the plaintiff in this case. So we can put a check mark next to physical contact or touching. So the plaintiff is going to be able to show that on a balance of probabilities. Then if we turn our minds to intentional contact, do you think that was intentional? Well, I think someone already addressed that in the remarks, saying the fact that she is disgusted with the plaintiff, that it seems as though it was their intent to direct that smoke in the direction of the plaintiff and for that smoke to come in contact with them. Okay, so I think we can put a check mark next to that element. The last element, I know there was a split among you in terms of whether that last element would be satisfied. The contact or touching must be either harmful or offensive to a person's reasonable sense of dignity. Harmful, as someone had noted, cigarette smoke can be harmful. It is a known carcinogen. The difficulty in this case, as I think someone else pointed out, that it's going to be very difficult to show any causal connection between any physical harm to the plaintiff here and any subsequent development of cancer or other physical consequences of being subjected to the smoke. So, unlikely to be able to show harm, but we have the word or. offensive to a person's reasonable sense of dignity. So now the question is, does someone suffer an indignity by having smoke blown in their face? And one suffers an indignity when one is humiliated or degraded. And so do you think in this particular case there is humiliation?
Yes.
Yeah, yeah. And so I think in this case, I think now it's a reasonable sense of dignity, and the term reasonable appears a lot in tort law. And so it's not enough for the plaintiff to show that their sense of dignity was offended. That's not enough. You have to put a reasonable person in the shoes of the plaintiff and say, would a reasonable person feel that their dignity had been offended? Is there anyone who thinks that that would not be offensive to a person's dignity? That if you felt offended, that would be unreasonable? Put your hand up if you do. There being no hands, I take it that we're all in agreement, all three elements are satisfied, and that we need not get hung up on the harmful piece to this because it's harmful or offensive. All right, so I think, in fact, she could succeed in a battery action.
I may just jump in. There was a couple quick questions from the chat
Sure.
that were
Yep,
sort of
jump.
related to what you were just talking about. So from a
Yep.
couple minutes ago, Catherine asks, so could someone deliberately coughing in your face when they know they have tuberculosis count as assault but not battery because of a lack of physical contact? We addressed a little bit of that, but
Yeah, okay, that's another fine question. So if someone coughs in your face and they have tuberculosis, they are delivering something to you. And so that would constitute physical contact. And there's a second question?
yeah, one comment, I think it was in response to the first, but I'll just read it anyway. Even though it's indirect, it is still unwanted physical contact, like spitting on someone or throwing something at someone, and smoke forces harmful substances into another person's space or body. Would you
Yeah,
say that's
no,
accurate?
Yep, great questions, and I think that would be the result. In that case, you might even be able to show harm, because to show that you now have contracted TB, well, if you can establish that really you haven't been around anyone else that has TB, now that could be difficult too. And remember, the plaintiff has to prove it on a balance of probabilities, more likely than not. Like I say, cancer is going to take years to develop, say, for example, so it's going to be harder to prove causation. TB might be a little easier, but then again, maybe you were exposed to someone else's TB. So you might not have the physical contact, but remember, you have the other piece, which is harmful to a reasonable sense of dignity. And so plaintiffs can hang their hat on that particular aspect of the third element. All right, so let's move on and let's now take what we know of the definition of battery and apply it to the Millett and Schulman facts. So can Millett establish the tort of battery against Dr. Schulman? Expressed another way, can Millett satisfy all three elements of the battery on a balance of probabilities? What say you? There's the definition again. Jessica.
I think no, because the touching wasn't harmful. It saved her life. And I don't believe it was offensive to her sense of dignity because the note wasn't witnessed. And so I would think that there would have to be standard procedure with things like this. And it's possible he was just following procedure. And since it wasn't witnessed, he had the right to believe that it could not have been accurate.
Okay, excellent. Does someone else want to weigh in? I saw another hand go up a second ago. I'm not able to track it. So anyone else want to just weigh in now?
It's Matthew, I think.
Was it Matthew? Okay.
I would say, yeah, I would say the battery is like for sure something that can be followed through with. just because I feel like it would be dependent on the card, I would say, but I would assume that it would be like within a reasonable doubt that it was like a sovereign, complete within their will person who wrote it, and that should probably be followed as like a respect for autonomy thing. I would say that would probably violate the respect, like the offensive part of it, of the or question.
Okay, okay, very good. Was there a third person, Matt?
There's a couple people with the hands up now. So I saw Anthony had said his hand went up after Matthews. He said for some reason the hand function doesn't always work. So I think Anthony jump in, and then
Yes, I definitely want to hear
Jennifer, I
from
think.
Anthony. He represents the doctor, so I'm very anxious to hear what he has to say. Hopefully, he doesn't speak in a manner contrary to his client's interests.
I more have a question than necessarily an opinion that's against my client's
Okay.
interest. Just
Okay.
wondering what a reasonable person's sense of dignity would be like in this particular case, because it has to deal with specific religious prohibitions that the plaintiff has.
Great
Are we
question.
considering this as a generic, like a reasonable person who generically cares about their whatever faith have they, or are we considering a reasonable person who is in our society? I don't think an average person does care that much. Like, does it factor into this evaluation?
Oh, fantastic question. I'll answer that in just a second. Very good question. There's a nuance there. Okay. Any other remarks?
Maybe Jennifer, and then Hripsamy.
Okay.
I have a question of what constitutes harm. So, if, like, say, like, this person received blood and in their religious community that's, like, really, really looked down upon, and then their mental health really suffers, and they, like, can't, like, have, like, a really hard time, and in their community with that. Is that harm, or does it have to be
Oh,
specifically
another great
physical?
question. Another great question. You guys are on the ball. I will answer
Yeah.
that in a second.
And then I was just gonna say 100% offensive to completely violate somebody's religious beliefs.
Okay. All right.
In my
And then I
yeah.
believe there's one very nice. I believe there's one other question.
Yeah, not a question, but I do think that it would, she could have success with battery. I do think it could be both harmful and offensive. I think it could be like we don't know how to define harm in this case, but I think it could be emotionally harmful, and like culturally harmful, but also offensive to their own dignity because it's not with their consent, I would say.
Okay. And who was speaking here? That was.
That was me, Haripsime.
Okay. Well, look, I'm not surprised to hear that from you,
And it was
counsel.
a signed note. That is one thing. I think it was signed, which is maybe enough for me.
Okay, counsel. Well, again, I'm not surprised to hear that from you, given who you represent. All right. So, all fantastic comments. Let's address them. Let's again deal with each element in turn. So in law school, on your exam, you are going to deal with each element and take each one in turn and apply it to the hypothetical facts. And everybody was doing that quite well, but you have to apply it to all three of them, even if it seems obvious to you. In an exam, you will go through each element in turn. Lots of folks focused on the last element there. But there's two other elements you need to turn your mind to. And so let's deal with those now, and then we will eventually get to the third one, the more controversial one, I suppose. Okay, physical contact, touching. Did that happen? What did it consist of? On an exam, you will tell me exactly what it consisted of. What did it consist of? When did it take place? What was the touching?
You're seeing through the skin and putting substance into your veins.
So it happened at the point that needle touched her body for the purposes of administering blood, right? Okay. So there we have our physical touching. Next, intentional. Was that touching intentional?
Yes, it was a decision he made because he figured it would save her life.
Absolutely. So state the obvious. So there was intentional contact because he desired the contact for the purposes of delivering treatment. It wasn't accidental. He wasn't walking through the ER with the needle in his hand, tripped on something, and then jabbed her accidentally. If that happened, there would be physical contact. There might even be harm, as we'll discuss in a minute, but it would not be intentional. So you could not establish the tort of battery. But there is another tort out there that might deal with that situation. What do you suppose that other tort is? If he tripped and unintentionally hit her with the needle.
Negligence?
Yeah, negligence law might take care of that, but you couldn't sue in battery. Okay, and that brings us to the third element. And so you folks were nicely considering things like, okay, so Hadskis, you told me it's either harmful or offensive to a person's reasonable sense of dignity, but you are a very bright group and you said, well, we need more information. Just what constitutes harmful contact? And what does it mean for it to be offensive to a reasonable sense of dignity? Does one take into account religious beliefs? Does one take into account that you might have a minority religion, that maybe a very, very small percentage of the population holds a belief in the tenets of that religion? Is it the case that if the majority doesn't, that can somehow define reasonableness? So you raised all of these questions, all good. Let me deal with harmful. Don't necessarily be focused on harmful being merely physical harm. It can consist of psychological or emotional harm. Often, psychological and emotional harm is more serious than physical harm. And so, in this particular case, the court indicated that she suffered psychologically as a result of receiving the blood in these circumstances. So that constitutes harm. So it's not just physical harm. How about the other part, the other side of the or? Offensive to a reasonable sense of dignity. The answer to that is, my goodness, thank goodness the law does not consider the majority to define what is reasonable. Think of this in this particular case as also being offensive because being touched for medical purposes against your will, no matter what reason you might have to say, no, don't touch me for medical purposes, it's my body. You get to set the conditions. And having set the conditions, we don't look any further. We say if someone touched you against your will, you might have had very good reasons not to be touched, bad reasons or reasons none of us can understand, or anything in between those two things. It does not matter. You made your declaration clear. Don't touch me. I don't care if you think it's in my best interest. It's my body. So for you to touch wherever you're for whatever your reason is why you don't want to be touched medically, if someone goes ahead and touches you, that's an offense to your dignity. You've suffered an indignity. Jennifer.
My question that was when you talked about intentional contact, you really talked about did he intentionally put the needle in her arm, but you
Yeah.
never talked about intentionally disregarding the card he saw. So like how does this
Another brilliant
whole
question.
thing change if he never saw the card?
Another brilliant question. And so your questions are actually bringing into play some other case law that obviously I haven't given you, but you see, you've been raising questions and you have an intuitive sense that there might be something more out there by way of law to clarify some of these things. And you have nicely put your finger on intention. What has to be intended? Does the harm have to be intended? Right? And the answer to that question is no. The only thing that has to be intended is the contact. You may have very good motives for wanting to touch someone medically or otherwise. But the question is not, did you intend the harm? It's, did you intend the contact? If you intended the contact and harm results, even though unintentional, even though unforeseeable, you would not have foreseen that harm unfolding, it doesn't matter. So it's only the intent to contact the other person's body, not the harm or offense. Right? So you'll have a case that will tell us all of this when you're in your first year contract or torts class, and that is the Bettel versus Yim case. And you'll study that in tort law. So good on you, sort of exploring some of the ambiguities in the information I've given you from Millett and Schulman. We need other cases, and indeed there are other cases that help us sort out some of these ambiguities. So great point, Jennifer, and great remarks, one and all. Okay, so we think, I take it, that Millett can show on a balance of probabilities, more likely than not, that there was physical touching. That's super easy. That's obvious. That it was intentional. That's also very obvious, given the fact that it only has to be the intent to contact. And then thirdly, that there was harm, and I'm telling you, she did suffer emotionally and psychologically as a result. So we can check that box. And in any event, it was also offensive to a reasonable sense of dignity. So nicely done. And here on the slide, here's the answer, basically, what we've just finished covering. And so on an exam, that's what your answer would look like. And then you would conclude at the end of this that it looks like she's made out all elements of negligence, or battery rather, and therefore she is going to necessarily be held liable. And that's not the case. So once she establishes the elements on a balance of probabilities, her work is done, but liability doesn't necessarily follow because defendants have the opportunity to raise a defense. So once the plaintiff has proven what they need to prove, then the burden switches to the defendant on a balance of probabilities, so more likely than not, that they can establish one or more defenses to battery. There are several defenses to battery. I've listed only 3 here. The first one is consent. And so one can consent to bodily interference with their bodily integrity. And a boxing match would be an example of that, where both combatants agree to the boxing match. And so you may have consent, and that would be a defense. And if the defense applies, there would be no battery. Self-defense is another. You won't be surprised to learn that if someone is about to attack you or is in fact attacking you, that you can defend yourself, which may involve you inflicting some bodily harm on the attacker. And that'd be self-defense. And if established on a balance of probabilities, that would be a complete defense to battery. Neither of those two are applicable on the facts of this case. The third one mentioned here, emergency doctrine. That's in red because that is an issue in this case. Can Dr. Schulman rely on the emergency doctrine? And so in the case, the full case, which you don't have, you really just have the very beginning of the case, which sets out the facts. Typically, when you read a case, the first part of the case, the judge sets out the facts, what happened. And then the judge goes on to explain the relevant law or set out the relevant law. And then they apply the facts of the case to the relevant law to come to some sort of conclusion as to whether or not there's liability in a tort, in this case, battery. So if you read the full decision, as you will in first-year tort law, you'll see that the court sets out 4 elements to the defense of emergency, the emergency doctrine. So the defendant has to show all 4 of these on a balance of probabilities. If they're missing even just one, the defense does not work and liability follows. So the first element of the defense is the plaintiff must be unconscious or without the capacity to make a treatment decision. What say you? Do you think that's established? Could the defendant, Dr. Schulman, establish that on a balance of probabilities?
Yes.
What do you think? Jessica? Jessica, what do you say?
Yes.
Yes.
The
Okay.
patient was unconscious.
Yeah, it's the facts are obvious. The facts tell us that she is unconscious. Now, keep in mind that that's certainly enough to establish that first element, but it's or without the capacity to make a treatment decision. So in some other cases, someone might show up to emergency, for example, completely inebriated, where they now, although are conscious, they lack the capacity to understand and appreciate the information, the medical information, and therefore may lack capacity. A person may show up completely conscious and be in an advanced state of dementia, and therefore lack capacity, and therefore the first criterion or element is established. So it's pretty clear. We can check the first box off, right? Okay, no problem. Now, time must be of the essence in the sense that it must reasonably appear that delay until such time as an effective consent could be obtained would subject the patient to serious bodily injury or death, which prompt action would avoid. Can the defendant establish that, you think, on the facts? If so, what facts would satisfy that second element?
Yes, because both Dr. Schulman and an independent surgeon at the hospital have concluded that if action is not taken immediately to restore blood volume, irreversible harm will be done to Mrs. Millett's life.
Yeah, absolutely. The medical facts are uncontroverted. She will go into shock, or there's a high probability of her going into shock, which means that she either is going to die or suffer serious damage to vital organs, which are deprived of oxygen, and the ability of the body to remove waste product is all a serious possibility leading to either death or serious bodily injury. Keep in mind it says serious bodily injury, so we have no difficulty checking this box off. In other cases, though, if someone shows up with, a broken wrist and is inebriated, now, are they going to suffer serious bodily injury if you can wait until they are no longer inebriated and can actually consent for themselves, i.e. they regain capacity? So there'd be some question as to whether or not the second element is met in that case. But in this case, in the Millett case, it is obvious that there will be serious bodily injury or death. As Anthony just said, the evidence is clear. 2 physicians have told us this, and there's no indication to the contrary. Okay, so 2, no problem. So it's looking pretty good for the defendant so far. we get to 3. No legally authorized substitute decision maker is available. Is that satisfied by the defendant who has the burden?
Yes.
Why? Doesn't
The daughter
show up?
The daughter doesn't have legally authorized consent to make the decision.
Okay. Now, how do we know that, Jessica?
Didn't have a POA available.
Okay, Janice. Janice is weighing in.
Yes. Does it matter that the daughter showed up later when the transmission already happened?
Yes. Okay. So at what point in time are those elements satisfied that we looked at that the plaintiff has to show? When she is brought to the emergency, she is unaccompanied by anyone. And so they do some medical investigations and are looking into things. And well before the daughter arrives, 3 hours after she is brought into emerge, the battery elements are satisfied by the plaintiff. Okay? So the fact that the daughter shows up 3 hours later is irrelevant. Now, she does show up 3 hours later, rather. And the question is, even if she showed up at emerge with her mom, is she a substitute decision maker that's recognized in law? And every province and territory actually has some laws in the form of a statute, which sets out who can constitute the substitute decision maker. There's a hierarchy. We need not concern ourselves with this in this case because the battery was perfected at well before the daughter arrived. So that box is checked, leading us to the last element that the defendant has to show. Under the circumstances, a reasonable person would consent, and this particular patient would probably consent. So there's 2 things going on there. Taking the first part of the 4th element, would a reasonable person consent in the circumstances? Lindsay.
I think it's reasonable to assume that they would want to live.
Okay. And the second part, the particular patient would probably consent. How about that? Because it's an and. It's not an or. Aiden.
Oh, I accidentally raised my hand, but I don't think this particular patient would probably consent. I don't think it's a reasonable assumption, given the circumstances surrounding the person's religion, that they would necessarily consent to the blood transfusion.
That's right. And, specifically the card. The presence of the card tells us that she would probably not consent. A high probability that she wouldn't consent. So that being the case, that 4th element or criterion is not satisfied. As I said a minute ago, all 4 elements have to be satisfied by the defendant to rely on this defense. And so it fails on element 4. And I have on this slide, the question though is, could Scholman claim that the JW card, which is the very reason why that 4th criterion is not satisfied, can that card be considered invalid? Is it sufficiently compelling evidence of Millette's expressed wishes? What say you? I heard counsel for Dr. Scholman, Anthony, made some submissions earlier on this. Anthony, do you want to repeat what you had to say on this point?
Yes. I think specifically on the point of the card, the first point is the card may have been signed under family or peer pressure. The second point is Mrs. Millett may not have been fully informed of the medical risks associated with signing such a card. And the third one is if Mrs. Millett, I suppose that's different, but if conscious, Mrs. Millett may wake up at that point and choose not to hold on to the card. And finally, Mrs. Millett may have changed her religious beliefs between the time she signed the card and the time she arrived at the ER.
Okay, do you folks find that compelling? Do you find his submissions compelling on this?
I find it compelling because how can you prove the card isn't a forgery? For example, the daughter could have forged this, put it in her mother's pocket, and caused the car accident because the mother has millions of dollars in the bank. So without a witness on this card, I think it'd be hard to prove that it's authentic.
Okay. Anyone else agree with that or take a contrary position?
I would probably take a contrary position just because, like, on the scale of probabilities, I would say it's like it would be very easy to invalidate any like medical type of card on those like bases. So I would say, like, just based probabilistically, it was signed, so logically it would go and carried on her person. So logically it would go to say that probabilistically, like, she did sign it on her own like fruition and like autonomy and like understood within a realm of reason like the associated risks.
Okay. Other points of view?
I would just agree with what he had said previously. Like if you're trying to prove something with 51% probability, you can introduce all these what ifs, what ifs, what ifs, what ifs. Is that actually more probable than she is a Jehovah's Witness and she signed the card? That's to me the most probable way. And if that's the way we're dealing with the law, we're not dealing with, well, what if this happened or what if that happened? But
Okay. Yeah, well done. Others?
I think the card. Oh, sorry. No,
Luke.
you can go. Sorry. No. Oh, hi. Can you hear me? Sorry, I have headphones on.
Yep.
Cool.
Go ahead.
I think the wording's quite strong. Firm religious convictions and under any circumstances, as well as listing alternatives, giving her reasonable affirmation that she knows the alternatives. So if the card is to be valid, it's pretty strong proof that she's researched alternatives and she knows that this is kind of her will.
Okay. One more comment, and then I will tell you what the court had to say.
I just think that the Jehovah's Witness religion has to be taken under scrutiny as well, that what kind of peer pressure were these people under signing these cards? Did they know that was it put to them either death or like were they okay with dying if they didn't receive a blood transfusion, or did they just think they wanted to adhere to the religious doctrine, they wanted to be good within the religion? So I think the religion and maybe like the mind controlling aspects of the religion would have to be held under some kind of scrutiny, as well as you think of parents signing these cards for children as well. So are those valid when a child is saying that they don't want blood and they would rather die? So it's very complicated.
Okay. Well, here's what the court had to say. The Court of Appeal in Ontario said that in the absence of evidence to the contrary, if one is to carry one of these cards, although not dated or witnessed, If there is no evidence to suggest that the individual was coerced or unduly influenced, or there is no evidence to show that she would have changed her mind in the ER if she had capacity, and in the absence of any information indicating that she did not make an informed decision to sign that card, then the card is clear, precise, and unequivocal, the court says, and that given that there is no contrary evidence, there's just speculation. So you're just speculating when you said, well, maybe she didn't understand. Maybe she was coerced or unduly influenced. Maybe she would have changed her mind in the face of almost certain death in the ER. But that's just mere speculation. There is no evidence to that effect. If there was evidence to that effect, let's say the daughter accompanies her to the ER, and when the card is discovered by the nurse and brought to the attention of Dr. Schulman, the daughter says, oh, by the way, she renounced her beliefs in that faith, or she doesn't believe in that particular tenet, then that would be evidence to the contrary. But that was not before the court, and that wasn't available to Dr. Schulman. Therefore, the card stands as is. There's insufficient evidence to invalidate it, and therefore the emergency doctrine does not apply. And the card needed to be respected. And the failure to do so meant that Dr. Schulman was deprived of any defenses, any valid defenses. And given that Ms. Millett can show the elements of negligence, or I keep saying negligence, of battery, then Dr. Schulman is liable. And what was he liable for? Well, in 1990, the case was decided in 1990 by the Ontario Court of Appeal, and she was awarded $20,000 at that time. In today's dollars, that would amount to just over $42,000. So that was her damage award. And that was calculated on the basis of the degree to which she suffered emotionally and psychologically. And so the court estimated her damage to be, as I say, just over $42,000. So that's the outcome of the case. Now, I'm going to return to the poll. Now that you know the law of battery, now that you know the rationale for the law of battery, particularly the rationale given in the context of medical treatment, specifically the law being there to protect the right of medical self-determination, I'm going to re-poll you again to see if there's been any change in opinion. So put your hand up if you think the defendant should be held liable. Okay, seems to be holding at 17. I believe it was 14 before, if I can remember right. Okay, but let's just check. Put your hand down. Everybody put their hand down. And now I'm looking for folks to put their hand up if they believe that Schulman should not be held liable. Okay, Lindsay remains unconvinced by the court's decision. Lindsay, let's hear from you. Why is the Ontario Court of Appeal wrong?
I just think there's serious issues with the card. It doesn't even say who she wants as her proxy. And I think there should be more information on the card of like the other things that a lot of these students talked about, you know, the date that it was signed, and someone else is a witness, then maybe we can put together, you know, do they still hold these beliefs? Like if this card was signed 10 years ago, maybe things have changed. And does she want her daughter to be her proxy health care decider? So I think more information on these cards is essential probably. And I don't think that the doctor was trying to, you know, cause bodily harm to her. I think he was actually, in fact, trying to save her life and actually did. Um, and I do understand, though, the facts of the law, though, that you're trying to get across. Sorry to be a pain.
No, not a pain at all. This is what every professor wants in the classroom is some dissent and some debate. And you by no means have to agree with the court. We teach you in law school to critically examine every single case you read, including decisions from the Supreme Court of Canada, many of which I completely disagree with. So you're strongly encouraged just to closely read decisions and not necessarily accept a judge's reasoning. And so that's a healthy thing, not being a pain at all. Now, I mean, you know, the Ontario Court of Appeal would respond saying, well, I know he didn't intend any harmful consequences. And I think, Lindsay, you just acknowledged a second ago that, yeah, the law actually doesn't require that for a battery. So the law as framed, the law that the Ontario Court of Appeal had to apply, didn't allow for the court to say, oh, well, he didn't intend harm to her, therefore a battery does not exist. The law doesn't allow for that. So they couldn't have reached a different decision on that basis. In terms of the card itself, interesting comments, Lindsay. You're still not particularly find that particularly compelling. I will say in most jurisdictions in Canada, perhaps even all jurisdictions in Canada, there's legislation for things called advance directives, where you get to name individuals while you have capacity. You get to create a document indicating who can make decisions on your behalf should you become incapacitated at some point. Those documents to be binding actually require a fair amount of information, more than what you might find on this particular card. So the law in statute form does require a little bit more for it to be a legally a binding document, the advance directive. So I don't know if you take any solace from that, Lindsay, but there you go. As I say, just to repeat what the Ontario Court of Appeal had to say, it said, well, we can't speculate. In the absence of evidence to the contrary, you carry one of these cards, the medical personnel have to abide by it. And by the way, you know, should you have renounced your faith and that you neglected to put that card, take that card out of your purse and destroy it, well, that is going to be on you. You can't later, or a family member can't later be said to say that card should not have been relied on. That will be on the card carrying person. And so the court did say that because Dr. Schulman said, look, you know, I'm going to get sued either way. Either I don't do anything and then the family brings an action against me, or I do something and then I get another action against me. So I can't win. Well, that was the court's response to that was, well, no, you won't be held liable if a person carries that card. It's going to be on them. And there'll be no action against you. Anyway, that's the decision. Any comments, any further comments or questions? Questions about tort law more generally?
I was going to say I agree with Lindsay that if the card had been witnessed or had a date on it, automatically would have stopped immediately because I believe in body autonomy and religious rights. But that card just would not have persuaded me to not save her life in that moment. And so I would have done exactly what this doctor did in that situation. And I know it's probably a difficult decision to make in the face of an emergency. So yeah, I do agree
Okay.
with Lindsay on that. But at the end of the
Okay.
day, the court made a decision. So I
There it
understand
is.
why. Yeah.
I'll put my Ontario Court of Appeal hat back on though and say, well, it's dated, but what difference does that make? So let's say it had a date, 5 years prior to the appearance of the ER. How does that change your point of view? And then if you don't trust the card, so it's signed. Who signed it? Is that signed? Is that it was a forgery? I mean, we don't have time to track down that witness and ask them questions about the state of mind of the person signing the card. We don't have any of that. So what more does it really give us, those two items? That's what the Court of Appeal would say. I'm not saying I agree or disagree with them. I'm just playing devil's advocate. And one should get used to that in law school because that's part of the fun. This is I guess at the time, somewhat of a controversial case. I can tell you now, though, it is well-established law and is cited by the Supreme Court of Canada, even to this day, for the principles contained in the decision. But the reason I included it is because, yeah, you can take two sides of this thing. You know, any other questions,
I might,
comments?
before folks with their hands up jump in, I'll just summarize a few of the comments that I'm seeing. There's a bit of a discussion in chat
Yeah.
around the validity of the card and whether or not, witness, signed, dated has any bearing on it. I think you just mentioned that. Hannah said, currently in 2026, Jehovah's Witness cards have to be or are encouraged to be updated annually and to be witnessed and signed. But perhaps that wasn't the common practice back then. Crips and me also had a comment about perhaps creating these cards with specific guidelines under specific guidelines might help establish the validity. There's also an interesting comment from Catherine earlier. It says, always get malpractice insurance. And I'm wondering if you can mention, I think there was a detail to this case that perhaps tort liability versus medical malpractice and the role of insurance in this case.
Okay, well, yeah, let me address all of those things. Yeah, like if I was to give advice to those that are interested in signing such cards, yes, by all means, have it dated, have it witnessed, have two witnesses. I mean, if your objective at the end of the day is to make sure your autonomy is respected, you want to make sure those reading the card are going to feel that it's compelling, right? They're not going to necessarily be aware of the Millett and Schulman case and the requirements, although this is often covered in medical school in some of the law classes that some schools have. But if your objective is to have it honored, by all means, make it as compelling as possible so that the person reading it is more inclined to abide by your wishes. So yeah, make it perfectly clear. Yeah, go do more than even the law requires to make sure that happens, that your wishes are respected. In terms of malpractice. So malpractice is a term that covers medical negligence, covers battery, and covers other torts that might occur in the context of delivery of medical services. So that's just an umbrella term that covers multiple torts. In terms of insurance, well, the vast majority, over 95% of physicians in Canada are members of an organization called the Medical Protective Association. And so they pay a premium. And What do they get for that? Well, if they get sued by a patient or a family member of a patient, if the patient's dead, for example, or incapacitated, then what they get are free legal services. And if a damage award is made at the end of the day, so if they lose the case and have to pay a damage award, the Canadian Medical Protective Association will pay that damage award on their behalf. They employ in every province, the Canadian Medical Protective Association has an affiliation with one or more law firms, usually large law firms in a given province. I'm in Nova Scotia, and so Cox and Palmer, for those that are local, they tend to represent the CMPA, so the doctors, and provide these free legal services and pay the damage award. And so in Ottawa, it's Gowling Strathy, so it's Gowlings. In Toronto, it is McCarthy Tetra, and other provinces. So they have highly competent legal counsel, most of whom do nothing but represent doctors in actions brought against doctors. That constitutes 100% of their practice. As well, in terms of the other side of things, well, you have plaintiffs, and plaintiffs have to get legal counsel. And there are legal counsel in every province that specialize in medical malpractice and represent plaintiffs. However, unlike with respect to the CMPA, the Canadian Medical Protection Association, who provide that coverage to physicians, there is no similar coverage for plaintiffs to sue. So they have to find a lawyer who will take the case, which is difficult for some plaintiffs to do. And typically, the plaintiff's counsel will take the case on contingency. What does that mean? That means they say to the plaintiff, I will take your case. I will waive all my legal fees. But if at the end of the day, you are successful in suing the physician or other healthcare provider, nurses can be sued, chiropractors can be sued, I will take 30%, typically around 30% of the damage award. What does that tell us? Well, that tells us that plaintiff's counsel then, for them to make money, they have to be pretty sure they're going to win, because if they don't win the case, they have all those losses as legal counsel, right? All the hours that you put into it, all the fees, extra fees, filing fees, etc., that you put into it, that's a loss. So they have to think, A, I have a very strong case, and B, not only do I have to have a strong case before me, I have to have a case where there's going to be a large damage award, because if I only get $10,000 at the end of it, and I'm only going to get 30% of $10,000, that's $3,000. That is not viable from a business perspective. So plaintiffs' counsel need to have a very strong case with a very large damage award to take it on. Otherwise, plaintiffs won't be able to get legal counsel and essentially can't sue. They can sue technically, but the prospect of winning now without competent legal counsel is close to zero. Anyway, I think that answers the questions. Let me know if it didn't. Great questions.
There's two hands up. Let's say maybe go ahead, Jennifer, and then Matthew.
Yeah. Hi. I had this comment and I also kind of put it in the chat. I heard several people point out that they don't know if this was coerced because of the religion, and I would take a great stance upon that, because when you like make laws and policies, they're not going to be specifically for Jehovah Witnesses specifically. It's going to be like if you were to make and be like, well, everybody who makes a medical decision based off their religious beliefs was coerced, and like that's not valid. So there's no religion in medicine. So now maybe if say the best thing for a patient whose religion precludes them from eating pork is a pig heart valve replacement. And you're going to just force that and say religion has no place in self-determination of medicine and medical care. Like, just like the repercussions of saying that, like, I just don't think, I think that violates way too much, and like that's not a valid point to make.
Excellent, excellent, excellent comment. All of which I agree with. Only partially addressed earlier when I noted that when it comes to establishing the elements and showing that it is offensive reasonable sense of dignity, the religion does not enter the picture at that point at all. Because to do that would, would be the tyranny of the majority. And so thankfully, that's not how that's interpreted. But that's only a partial answer to your comment, because the other piece of your comment, which is, we have to be seriously careful about speculating and assuming certain things because a person is a member of a certain religion. Again, that could be based on stereotype. And I think the Ontario Court of Appeal, indirectly addresses that when it states that, you are speculating at that point that there was coercion or undue influence. And, to suggest that that is inherently part of any religion without any factual foundation specific to that individual, there is no foundation. So it amounts to nothing but speculation and maybe feeding into stereotypes. And so that's not going to be deemed to be compelling evidence. So a fantastic point, and as I say, I would agree with it, and I think the law, you'd be satisfied with Jennifer in terms of the stance that a court would take on those things. Does that answer your question or address your comment?
Yes, thanks.
Yeah. One just has to be very careful. Again, you carry this card, there are going to be consequences, but we can't make assumptions. That's the court's position. We just can't make assumptions. It's way too dangerous.
Yeah, I was just gonna make a comment and then a question. Just on the case of this particular case, it seems like part of the difficulty with it is like equating morality and legality. Like a lot of us are looking at it from like the non-religious stance and like assuming that the preservation of life should be like the necessity, which again, like kind of you pointed out, isn't the normative stance in law, given like that would be kind of tyranny of the majority, as you said. So I feel like that was part of the difficulty with the case, is that like we were looking for extra evidence for the note when it's not necessarily required. And the question I had is, I was wondering if you could, in a sense, I know it'd be a bit of a false equivalency, but equate like the note almost to like when you tell your doctor you have an allergy to a medication or something. Like if I tell my doctor I have an allergy to like ibuprofen or something like that, they either won't do the treatment or they'll look for an alternative. And there won't necessarily need to be like a stringent card that's dated or signed or has any like witnesses on it or anything like that.
Okay, yeah, fine comments. The first comment I'll address first. In terms of the case, Dr. Schulman argued, or the Canadian Medical Protective Association's lawyer argued on his behalf, that his profession requires them to do no harm, and they feel compelled to basically treat someone and save someone's life. That's sort of very foundational to their beliefs, to their training. The response to that the court had in the decision, and by the way, if you just Google Millett versus Schulman, Ontario Court of Appeal, you will be able to look at the full decision. And so you can see everything that I've been discussing in terms of what the law was. So feel free to do that if you're interested. It's a longer decision. It's got to be 15, 20 pages in length, but it's good reading. And so what did the court have to say there, which is actually, it is, at the end of the day, the doctor's, what the doctor thinks is in the best interest of the patient is irrelevant. Patients get to determine what's in their best interest. And, you know, obviously, given that doctors are to do no harm, well, one harms a patient if they administer treatment against their will. So that argument advanced on behalf of Dr. Scholman did not work. And what was your second, Matthew? You had a second point there that yeah, what was your second point again?
Sorry, I was just wondering about if you could equate the note almost to like an allergy at the doctor's. Like if you were to give an allergy, like tell your doctor you have an allergy, they just won't be asking for like a dated note or anything like that. I get the circumstances is a bit of a false equivalency, but I'm just wondering to what extent do you really need a note for
Well, you don't need any notes. So you show up at the doctor and you're an adult, and this actually ties into a passing comment someone made earlier, like what happens if it was a child? So if you show up to a physician and you are an adult and you appear to be competent, like there's no reason to believe that you're not competent, you don't need any note. You just verbally say, I will, I consent to the treatment or I refuse the treatment, doctor. In either case, it has to be respected. If you're
if you were unconscious, would you need a note?
If you're unconscious.
Would you, so why would that significantly change if you're unconscious? Like, why would the note have to be, like, have any extra information other than just, like, the information
I didn't realize we were dealing with an unconscious person who needs, like, well, then you wouldn't really have an emergency, right? Remember now, the emergency doctrine requires serious bodily harm or death. If you're incapacitated, you're just going to wait if you're a physician before you administer anything to the person until they're competent. This is really dealing with circumstances where if you don't administer treatment in a timely way, you're looking at some dire consequences. So the answer to that is you just wait till they have capacity. In terms of the minors, someone asked a question like, what happens if you just showed up and you were a minor with a card? Can you refuse treatment? And that's actually a very insightful question. And for those students interested, this is addressed directly by Supreme Court of Canada case called AC, just the acronym AC, which is the initials of the minor, the court's protecting their identity, AC versus Manitoba. And that involved a minor who was 14 years, 10 months old, who has Crohn's disease, is bleeding internally, and will go into shock if they don't receive a transfusion. They are a member of the Jehovah's Witness faith, and they said, I do not want to receive blood product. And the question before the court, and we were all waiting to get some certainty around this because the law was unclear, when can a minor refuse life-sustaining treatment? And that brings into play something called the mature minor doctrine. And the Supreme Court of Canada AC set out certain circumstances where a minor can refuse life-sustaining treatment. And they put some criteria around that, which I won't go into now, but if you're interested, look at the AC case. And if you're still interested and September rolls around, by all means, come to my office. I'd be happy to talk to you about the AC case. It's a classic health law case, super interesting. And I'll say no more than that. That's more or less just a teaser for you to go have a look at the case or come and see me in September. Health law is fascinating. Tort law is fascinating. Am I right, Matt, who's in my tort law class? At least about tort law?
Yeah.
Have I put you in an awkward position, Matt?
Oh dear, how do I answer this?
Yes, exactly. You have the right to remain silent.
Yeah. No, honestly, I feel like even just chatting with my classmates, chatting with folks who like everybody loves tort law. Tort law is exciting. You get into all of the juicy kind of facts of the cases where, there's either drama going on, there's some kind of conflict, somebody's suing someone. The facts are always really interesting. Sometimes in cases of, I don't know, not to throw any of my other courses under the bus, but property or contracts or something, they can be a little dry. You're learning some fundamental
Sorry, Matt,
principles.
you don't, perhaps you're incapacitated. All the courses at the Schulich School of Law are fascinating. That's what you meant to say.
That's exactly what I meant to say.
There we go. There we go. Talk about coercion and undue influence. The truth is, certain subjects really, some people gravitate toward and others not. I don't at all assume that everybody thinks that tort law is fascinating. I think a large number do, but some folks just really love contract law and get very excited about contract law or property law. I mean, there are exciting issues in property law. Can you have a property interest in human genetic material? Can you own animals? There's all kinds of intellectual property issues. That's huge these days. So anyway, I'm just trying to sell all the courses. I'm doing my best to do that. But yeah, it all depends on what your thing is. And the great thing about first year at the Schulich School of Law is you really have no choices. You get exposed to a number of fundamental areas of law. Property is a full year course, contract, criminal law, tort law, and something called public law. Those are your major substantive courses. There's intensive courses that are interesting too, on indigenous law and other sorts of things. And so you get exposed to them, you see what really captures your imagination. There we go. Sorry, I cut you off, Matt.
Not at all. I was gonna say, well, I felt compelled to talk up the torts class in this particular venue, but I should say there are some incredibly lively discussions in all the classes that, yes, like Professor Hadskis reminded me about. There was in our property law class property interest in genetic material, intellectual property, hugely interesting. Every class, I think you'll find a ton of really, like, these are really fundamental issues that you start digging into in first year. The cases that are chosen for a reason, and yeah, there's a lot there.
Yeah, it's interesting. Any questions about law school more generally, or before we wrap things up? All right, is there anything showing up in chat? If there isn't,
no, I think we're all good in the chat.
We're good. All right, then. Well, look, this has been fantastic. I mean, you really were very engaged, had fantastic questions. In many cases, you were sort of identifying other law that must be out there to answer some of the questions I was asking. And I mean, those are really strong questions. And so I enjoyed the session, and I hope to see you all in September. Legal counsel for Schulman and Millette, by all means, hopefully you show up in September. And if you do, you're going to swing by my office, and we're going to set a date to have some pastries and coffee. The rest of you, honestly, don't be a stranger. You can, if you're potentially interested in health law, also feel free to swing by my office to chat out. I always have lots of time to talk about that. Okay, so with that, again, thanks so much. And I am going to bid you a good night and head home.
Thank you
Thank
very
you.
much, Professor Hadskis.
My pleasure.
Thank you. Good night.
Right. All right, Matt, you're gonna stop